Hello and welcome to Triage, rapid legal lessons for busy healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
Welcome to this episode of Triage. My name is Andy Ruskin, and I'm a partner in the firm's Washington, D.C. office. My practice focuses on healthcare regulatory matters with a focus on Medicare and Medicaid coverage, reimbursement, and compliance issues, including the 340B drug pricing program.
And I'm Victoria Hamscho. I'm an associate in the firm's Washington, D.C. office, where my practice focuses on healthcare policy and regulatory matters. In this episode of Triage, we will provide an update on recent developments in the 340B program, and in particular, on two recent legal challenges stakeholders brought in response to drug manufacturer contract pharmacy actions, where they are requesting, among other things, for HRSA to promulgate 340B Administrative Dispute Resolution, or ADR regulations, which we understand HRSA recently sent to the Office of Management and Budget for review in light of the ongoing litigation.
By way of background, the 340B statute requires drug manufacturers to sell covered outpatient drugs to covered entities participating in the 340B program at or below a defined 340B ceiling price in order for their drugs to be covered under Medicaid. When there is an overcharge dispute between covered entities and manufacturers, HRSA generally recommends that covered entities work directly with manufacturers in good faith to resolve the dispute. Covered entities may report an overcharge using a form that Apexis, which is HRSA's 340B prime vendor, has made available for reporting overcharges, though it is unclear what action, if any, the agency takes following such reporting. Covered entities may also file an overcharge complaint with HRSA, which the agency reviews through an informal dispute resolution process. That process, as outlined in a 1996 notice, requires covered entities to submit a formal request to HRSA's Office of Pharmacy Affairs, which is then reviewed by a committee that is in charge of informing the party that committed the alleged violation and requesting any rebuttal it may have. The committee reviews the request and rebuttal information for evidence that a good faith effort was made to resolve the dispute and the reasonableness of the allegations, while then providing a decision which covered entities may appeal within a given time. According to the GAO, the process has only been used a handful of times. In 2010, Congress required the Secretary of the Department of Health and Human Services to promulgate formal 340B ADR regulations as part of the Affordable Care Act. In 2016, HRSA issued proposed ADR regulations implementing that section of the Affordable Care Act, which the agency withdrew without explanation in 2017. While HRSA has increasingly taken the position in recent years that it lacks statutory authority to issue and enforce 340B program sub-regulatory and regulatory guidance, it is worth noting that the United States District Court for the District of Columbia found in 2014 that, in fact, the 340B statute does authorize rulemaking establishing an ADR process consistent with the ACA.
Against this backdrop, several drug manufacturers have taken actions over the past few months to limit contract pharmacy access to 340B pricing. As listeners are aware, HRSA has permitted covered entities to contract with a pharmacy to provide 340B services since 1996. While covered entities were initially limited to using an in-house pharmacy or contracting with a single contract pharmacy, HRSA issued contract pharmacy guidance in 2010, permitting covered entities to use multiple contract pharmacies. In July, Eli Lilly announced that it would cease distribution of its drug Cialis to 340B contract pharmacies and limit distribution to covered entities in their child sites only, a policy that Eli Lilly later on extended to its other products effective September 1st. AstraZeneca similarly informed covered entities that it would stop replenishing drugs to 340B contract pharmacies beginning on October 1st. Both Eli Lilly and AstraZeneca offered a carve-out for covered entities that lack an in-house pharmacy. At the same time, Merck, Sanofi, and Novartis began requesting that covered entities share contract pharmacy claims data through Second Sight Solutions' 340B ESP platform, with Sanofi and Novartis explicitly indicating that much like Eli Lilly and AstraZeneca, they would also cease replenishment to contract pharmacy locations for entities that do not share their data. While we understand Sanofi has moved forward with its policy, it appears as of this podcast that Novartis has yet to implement the new policy. Despite multiple requests from 340B covered entities and provider groups for HRSA to intervene and enforce its 2010 guidance supporting contract pharmacy arrangements, HRSA initially indicated in its early response to these developments that although its 2010 guidance remains in effect, it is not legally enforceable. And while HRSA has taken the position that its authority to enforce guidance is limited unless there is a clear violation of the 340B statute, HRSA has more recently indicated that it is considering whether the drug manufacturer policies violate the 340B statute and whether sanctions may apply.
In response to these actions by these various manufacturers, on October 21st, the National Association of Community Health Centers, which represents federally qualified health centers, or FQHCs, filed a complaint in the United States District Court for the District of Columbia asking the court to compel the Secretary of Health and Human Services to issue the 340B ADR regulations that had previously been proposed and withdrawn. The ADR regulations, if finalized, would replace HRSA's current informal dispute resolution process. The FQHCs argue that other than the ADR regulations, covered entities have no other, much less an adequate remedy to challenge the drug manufacturer's actions, stressing that HHS's inactions in this regard is harming FQHCs and their patients. Despite some early indications that HRSA may hold off on issuing 340B rules, despite its perceived lack of authority, HRSA recently sent 340B ADR final regulations to the Office of Management and Budget for review and ultimately for publication. This appears likely in response to the ongoing litigation regarding contract pharmacy actions. While it is unknown whether the final rule may differ from the 2016 proposal, it is worth noting that the proposal provided for the establishment of a panel to perform the ADR, a claims submission protocol, including a 3-year filing deadline, documentation requirements, the allowance of joint claims against multiple manufacturers, and an informal submission process, and then finally, the ADR procedure itself. The regulations would allow covered entities to force manufacturers to the table in a binding ADR process that would result in a final agency decision on whether a manufacturer failed to offer the 340B price in violation of 340B rules.
Also in October, Ryan White Clinics for 340B Access and 2 of its members filed a complaint in the U.S. District Court for the District of Columbia, asking the court more broadly to compel the Secretary of HHS to enable them to use contract pharmacy arrangements, arguing that they are being harmed by the Secretary's failure to enforce their rights to 340B pricing because such pricing allows them to provide services that they will need to scale back or otherwise eliminate unless the Secretary intervenes. Like the FQHCs, the Ryan White Clinics are asking for an order requiring the Secretary of HHS to promulgate the 340B ADR regulations, arguing that by failing to implement the ADR process and failing to take action to enforce a right to contract pharmacy arrangements, the Secretary has deprived them of their property interests under the Due Process Clause of the Fifth Amendment and procedural due process rights. The clinics also argue that HHS's refusal to enforce the rights to contract pharmacy arrangements is arbitrary, capricious, an abuse of discretion, and in violation of the Administrative Procedure Act. In this regard, they're asking for orders directing the Secretary of HHS to 1. Enforce our rights to purchase and dispense drugs to contract pharmacies at 340B pricing. 2. Force the manufacturers to refund them for overpayments on drugs they have refused to sell at 340B prices when ordered via contract pharmacy arrangements. 3. Impose civil monetary penalties upon drug manufacturers unless and until they honor contract pharmacy arrangements. And 4. Revoke the pharmaceutical pricing agreement of any manufacturer that does not offer drugs at 340B pricing when ordered via contract pharmacy.
Notably, on November 23rd, the Ryan White Clinics filed a memorandum requesting an injunction directing the Secretary of Health and Human Services to issue the 340B ADR regulations in spite of OMB's review and protect covered entities' right to contract pharmacy arrangements, as well as a declaration affirming those rights. In regard to the 340B ADR regulations, the Ryan White Clinics argue that judicial intervention is necessary because OMB's review does not guarantee that the regulations will be finalized, noting that the ADR regulations have been delayed before as well as the 340B civil monetary penalties regulation. The clinics further argue that even if the regulations are finalized, they will not take effect until it is too late, adding that the process will likely stretch into months, if not years, while patients lose access to needed drugs. The government's response is due December 12th, with Eli Lilly and Sanofi recently asking to be defendants in the case. Because their 340B policies are distinct, they argue that they should be allowed to join the suit separately. Eli Lilly is arguing that contract pharmacies are not allowed under the 340B statute, and that if the Ryan White clinics prevail, it would be difficult for the company to prove its interpretation of the 340B statute. Sanofi is arguing that, as government parties, the defendants cannot represent its interests. The future of the 340B ADR regulations is unclear. OMB must review the regulations, and they may still be subject to delay or withdrawal by President-elect Biden's administration. Once finalized, it is possible that the ADR regulations themselves will be challenged in court, should either side deem them more favorable to the other side. After they are finally published and some version of them is upheld in court, the timing of the process will be uncertain, as will be questions regarding the rights of the parties to challenge the ADR process in court. In other words, it may be a very long time before the actions challenging the validity of contract pharmacy 340B drug utilization are found to be lawful or not. As we have mentioned in previous 340B updates, given the ongoing contract pharmacy actions and challenges to the same, it is possible that Congress may decide to step in. The manufacturers' contract pharmacy actions have attracted the attention of a number of policymakers in both the House and Senate, which have written to HHS and the pharmaceutical industry on this matter. However, Congress may now be somewhat more hesitant to take any action, as it will not want to overstep its bounds with the litigation pending in federal court. Even if Congress works on a legislative fix to these actions, it would likely come with new overarching program authority for HRSA, along with enhanced transparency requirements, which could greatly impact the 340B program. K&L Gates will continue to monitor these developments. Thank you again for listening to this episode on recent developments in the 340B program. Please do not hesitate to contact us if you have any questions.
Thanks again for listening to Triage, rapid legal lessons for busy healthcare professionals. New episodes are available for download through iTunes, Google Play, and other podcast applications. By subscribing to Triage, you will receive timely notifications of each new episode. Also, if you have any topics that you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.